among Galatas. I want to put a broad conversation, not relating to what your conversation is, but it's relating to strike. Though. You remember some few months ago, the teacher working union and other trade unions went on some strike because of Galamsey. There's a whole lot of back and forth. Then we ask ourselves that when it comes to strike actions in the remit of the law and what the regulations are saying, who is wrong and who is right? Is the demands they are making that because of Galamsey, we are going on strike, is it legitimate? You are the only person I can bully you with this question.
Well, good evening once again to your cherished viewers. I will say that in the first place, the strike action that they took, it wasn't within the remit of the commission. Mm-hmm. So the commission was a bit silent on pronouncing on the legalities of the strike because it was actually not within our jurisdiction. You realize that the labor law provides that whenever there is a dispute between the employer and the employee, that is when the matter will have to come before the commission, so that it will be addressed. In this instance, there wasn't any working relationship between the union and the galamseyers. And so there is no direct relations within which the commission could make any pronouncements on. So I will leave it as it is.
Okay, let me also leave it as it is. So that, well, if I have to go into industrial matters, then maybe we'll be calling a lot of matters. It's fine. Well, let me come to you, Totime. Or maybe I have to start with Mr. Samuel here on making this what we started with strike. How do we define strike and then lockout? What is the distinction between each strike and then a lockout?
Well, thank you, and good evening to our cherished listeners. Wait, let me try to be very explanatory, not being too technical, so that the language and the terms can be well understood by our listeners. And so when we talk about strike, we are talking about any activity that a worker or a group of workers will engage or embark in that will, in either short run or a long run, affect the output or interrupt the productivity of an organization or an employer. In that case, it is a strike action. It takes various forms. On the other hand, there will be a lockout when, for any reason, the employer thinks he does not need the presence of the workers. In that case, before the workers come, the place is locked out by the employer. So the workers remain outside. That is a situation of an outlook.
Okay. So in these two instances, if I get this right, in my lay understanding, meaning that to define the action, in whichever way production is affected, depends on who is causing the action.
Yes.
In the case where the employees choose not to go to work, that one is a strike.
It's a strike action.
But in the case where the employer, the owner of the job, I say that, okay, I don't need you, so I lock out the premises, that is a lockout.
Precisely. Normally, the lockout is initiated by the employer.
So is it safe to say that the strike actions are being called by the employer, and then the employee, and then the lockouts are being called
by the employer?
Okay, fine. Again on you, in what instances can an employer say that, an employee say that we are embarking on a strike? In which instances?
There are so many instances, but it is largely seen from the economic point of view, where the workers will feel that their remuneration, their payment, working conditions, or other emoluments are not the best and demand for a better condition of service. If this is put before the employer and attempts have been made to reach a settlement or an agreement that has not been fulfilled for a prolonged period of time, and that the workers feel that it is a deliberate action by the employer to cause them to suffer, then they decide to resort to a strike action, because it is believed that when persuasions fail, force must be applied. And so when a strike action comes in, it pushes the employers mostly to listen to their demand than when they are attempting to negotiate.
Okay, just let me come to you. Having and have the understanding of what constitutes to strike action. Now, can we say on the same basis of economic factors on lockouts, or at what instances can the employer say that okay, I'm locking out my premises?
Well, it depends on multiplicity of factors. One, the employer could consider that the work output of the employees are not up to the standard that is required. And as a result, it is rather losing or not gaining the profits that it is supposed to recoup at the end of the day. It could also be that the employers are deliberately causing havoc at the workplace, and as a result, he may want to put that as deterrent measures to curtail some of these concerns that are there at the workplace. But you see, when lockouts are carried out, most often it is the employer who loses. He initiates it, as my brother rightly explained. It is mostly the employer who initiates the lockout, and he suffers. That is why it is very rare to hear on lockout issues, but strikes are very rampant. That's the difference. Because at the moment a lockout is carried out, it means that the facility is closed down and one cannot have access to. There are instances that the employer will initiate a lockout simply to do away with some of the workers. And at the time that he will even want to reopen the organization, may not want to bring them back to work with them. It's an indirect way that they can use to terminate employment of some workers. Yes, so at most times, whenever a lockout is called out, it has economic implications on the employer.
Okay. So
let me quickly add to it. In some instances too, when there is unresolved dispute, particularly when workers are trying to have certain demand that employer is not yielding to, and the actions of the workers are gearing towards damages that will cause the employer. In the wisdom of the employer thinks if he lock out, it's safer for him than to bear the damage that they will cause.
So for what you're saying, some strike actions may lead to a lockout.
Yes.
Especially if the activities or the doings of the employees in the course of their strike actions are damaging properties.
Yes, are gearing towards damages.
That means that the employer can lock out. My concern is that to understand lockout properly, does it mean that like probably maybe the Minister of Education wakes up one day and goes to lock all schools and says that teachers are not going to school? Is it a typical lockout?
Well, you may want to call it a lockout, but then what are the reasons why such action? It is also an industrial action. Such action will be carried out at that particular time, and it will be very rare.
But just to understand,
for any such thing to happen.
Employer, right?
Yes, because you see, even with the issues of strike, look at the total number of teachers that we have across the country. We may be having over 150,000 teachers across the country. And at any given time, when they even choose to go on a strike, a sit-down strike, for even 1 hour, it has very serious implications on the economy. And so I don't think that it will be very prudent on any administration of the day to carry out a lockout, as in closing down facilities which will prevent workers, legitimate workers, from embarking on their day-to-day activity.
Interesting.
Yes.
It's not actually common in the service areas, but then most often it happens in the production areas,
In the production
where the
setup.
factory,
Yes, exactly.
factory floor and other places like that.
That's wonderful. But this year, per your statistics, have you been able to experience some lockouts?
I would say no. For lockouts, we haven't recorded any.
No,
It is
as of
strikes.
strike, the China.
Yes.
Yeah.
Per our records, as it stands, we have received about 28 strike actions in this country this year alone.
Even Closac went on 3 days.
So for strikes, they come very often.
Okay, so it's good. You also your work, you eat strike.
Well,
So every day you go to the work expecting one strike action.
you see, the Labour Commission is established to resolve issues, labor issues.
Okay.
Without these issues coming up, we are not working.
Government will not pay you. So in your case, if you have issues,
But
with
we don't
government,
contemplate
you go
it
on
comes
strike.
because it can never end.
In your case, if NLC people are having concerns and you go on strike, who is going to resolve your issue for you?
Well, the Minister of Employment and Labour Relations can have an intervention in this matter.
Okay.
Yes, and maybe high-powered government offices like the Council of State can also intervene, or even from the presidency.
So we are a special case.
Yes.
Okay, that's fine. Anyway, so when it comes to such industrial actions, by way of the regulations and the remit of law, what is the duration we have to say that the employees can embark on a strike action within which confine? How many days can they go on? And when it comes to lockouts too, for how many days does the law permits for such lockouts to happen?
Okay, so when we want to talk about permissible period of time, then we must be certain to define that the action is lawful.
Okay.
And so for the action to be lawful, it means that when a dispute arises and the parties attempt to settle or arbitrate on the matter, that the arbitration process fail, or two, the parties disagree to refer the matter for voluntary arbitration. In that instance, they are supposed to write informing the other party as well as the Labour Commission that they have lockout and therefore intend to go on a strike. So such letter must be received by the other party and the commission 7 days before the action is embarked upon.
Okay.
And anything less than 7 days will mean that such action is unlawful.
Anything less than the 7
The
days.
7 days, yes. Upon which the commission, not when the letter is written, but 7 days upon the commission receiving the
letter.
Yes.
Okay. We spoke about unresolved issues. Does it mean that the issues can arise before the strike action is taken, or when the issue comes up, even in the wake of it, we go on a strike to resolve the issue? What comes first?
When a dispute arises, the demand is that the parties must attempt to resolve it.
But not on a strike action yet.
No.
Okay. So
The first instance is to try to resolve. And when you are unable to resolve and also unable to refer the case to a voluntary arbitration, that is when you have to notify the commission and the other party of your intentions to embark on the strike.
So you've been mention of voluntary
Arbitration.
Yes.
twice. What is it?
The voluntary arbitration is the process where the parties willingly nominate or appoint an arbitrator to adjudicate on the dispute.
So the arbitrator can be somebody not from the Labour Commission, or should be somebody from the Labour Commission?
Not necessarily from the Labour Commission. When the matter is before the commission, then the arbitrator must be somebody listed on the commission's database of arbitrators.
Okay. But in terms of the voluntary arbitration, the parties can decide on who.
Yes.
Okay.
It is always their right.
All right, that's fine. That's wonderful. Now, Totime,
Yes.
my other concern is that he's made mention of some 7 days. That is when the commission is being notified. But before the commission is notified, and the dispute remains unresolved as after 7 days, for the strike action then comes in. What becomes the other steps to be taken after this unresolved voluntary arbitration, or even not even going for it at all?
Well, so if the matter comes to the commission, ideally it must be handled by the 7-member panel of the commission. Now, if they sit on the case and it is unresolved, it may be that the matter has been referred for a negotiation between the parties to go and then have a table discussions and come back to report on their issues that they have been able to agree on. But in instances that the parties chooses to declare the strike before the matter is heard, then the commission comes to sit and now makes a determination as to the legality or the illegality of the strike. And just as he mentioned, when the strike, when there is an intention to embark on the strike, the parties will have to notify their employer and then the commission. And the beauty of this clause in the act is to ensure that the commission invites them, whether the employer meets with them or not. The commission invites them, sits down with them, and get the matter trashed out.
Okay.
And so within the period, the commission will certainly invite them for a hearing.
So that means that even in the framers of the regulation, it is done to even be amicable.
Yes.
In a way that before you even go to the extreme of calling on a strike, there's a need for dialogue. Let's have conversations.
Exactly.
Let's talk.
Exactly.
Let's understand the issues.
Sure.
Let's see what can be done before we go to the extreme.
Yeah.
Okay. Now, when the matter comes to the commission proper, now, okay, before that, in this country, the strikes that I have heard, sometimes I see Labour Commission comes to say that, okay, the strike action is unlawful. And then some people are giving some ultimatum to return to their workplace, to the work post within some number of days, among other things there.
Yeah.
It keeps occurring. It's not like it's unending. All the time it surfaces itself. Does it mean that they are not afraid of you people? Or they think you can't do them anything? So you just get up and go on strike without even going through the attempt to even resolve the issues before. But they come write long statements, they invite you in the media, they give us about 14 pages document that chronologizes they had a meeting on this day with this person, blah 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 blah, and strike action is taking place.
Yeah, we don't want to assume that the union leaders always have an idea about calling on strikes.
Okay.
There has been instances that strikes have been called and it has appeared before the commission, and going through the proceedings, we have realized that the union leaders had limited knowledge in even calling the strike. There are instances that local unions even calls strike. Meanwhile, a local union with the Labour Act does not have the mandate to declare a strike action.
Let me understand. Local union. So maybe TEU
Yes.
for Apoli. It is a local union.
Yes.
They don't have the right to call for strike.
They do not have the right. It's only the mother union,
So TEU National.
TEU National,
Exactly.
they have the right or the mandate. They are given the mandate by the law to call a strike action.
So in the case that a local union calls for strike, what do people do to them? You leave them, you watch them.
No, we invite them and we invite their leadership also. And then we tell them in the face that the strike that they have embarked on is illegal. It is illegal. Just example, yesterday there was a ruling by the commission on the illegal strike that TEU have called in the country. Those, for some few days they've been out of the classrooms or the school compounds. They declared a strike. And the processes that they were supposed to go through before the declaration of the strike, they didn't follow it. And so upon appearing before the commission, we declared that it was illegal. So first of all, they should even go and call off the strike before they can appear before the House. So the commission ruled on it. And this day, in your media and elsewhere, there have been publications. They will have called off the strike because it is illegal.
Okay.
See, the steps are there. The law says that notify your employer and the Labor Commission 7 days before you declare the strike. Failure to do this, it makes it illegal. And the framers of the of the Labor Act are very knowledgeable. They know that within the 7 days, come what may, if you notify the commission, wherever you are using to the problem that is there.
So, the other concern is that when the matter comes to you, per the letter I've read on the website, is that you go by 3 approach. You do negotiation, you do mediation, and then arbitration. Let us understand what these things are. What then can we say is negotiation? At what stage? At what point are we negotiating? At what point are we offering mediation? And at what point too are we saying that it's an arbitration matter?
Well, let me start this way. Commission is not mandated to negotiate. Negotiation is supposed to be done by the parties themselves at the enterprise level.
Okay.
And so when a dispute arises, it is expected that the parties engage and judge or talk among themselves as to how best they can resolve the issue. And that is negotiation. When negotiation fail, or if there is a deadlock upon the negotiation, the matter is referred to the commission for mediation. And if mediation process fails, the mediation is also a voluntary process, but the mediators do not make decision in the matter. They help the parties to they make decisions for themselves by the guidance of the mediator. Now, when mediation
That's like
fails,
what happens in the law field, where mediators do not make a decision, but they help, they guide the process to ensure that both parties come to an agreement.
Exactly. And so when mediation fails, it's referred back to the commission, and the parties are taken through processes to get an arbitrator appointed. Now, the arbitration process is an adjudication process. The arbitrator appointed has the powers of the High Court judge. And so he makes a decision in the process. That decision is binding upon the parties, and they are to comply. It is only challenge on questions of law. In absence of that, the parties are supposed to comply by the decision, by the award of the arbitration process. So that is what it is. Now, that is the case of voluntary arbitration. Yes.
Are the similarities and differences that are there?
You made mention of the fact, so the mediators, you have mediators at your place, at your end, or we can choose to have anyone to mediate or guide the process?
Well, a mediator should be somebody who have at least some background knowledge about the labor law, and then he has an expertise in a certain area or specialization also. So, for instance, if there is a problem between workers of Adwa TV or a worker of Adwa TV and then management, and the matter is brought to the commission, we have the list of mediators who operate in the country. We give both parties the list, and then you select the one that you feel can best handle, because we have their CVs in there. So maybe you may want to appoint somebody who has a media-related background, because he can understand your terms and your jargons and everything. Exactly, much more better than somebody who is working in the mines and is a mediator. So we give you the list, and you choose from amongst the list. You choose 3 persons. Your employer also chooses same. We look at the similarities that are there. If there are no similarities in it, then the commission appoints one for you.
Well, are there any consequences if anybody violates some of these restrictions?
As in the
restrictions that probably will govern negotiations mediation arbitration processes if it arises that somebody violates them. For instance, after an arbitration, and an arbitration is given, and somebody violates that ruling, I should call it.
That what?
Yes. It can. It's the parties. You see, it's not sacrosanct. Let me put it that way. It doesn't end there.
Okay.
If the parties feel dissatisfied in the process, they can go to court and then seek for some legal interpretations on certain things. So that one can be done. And it is incumbent upon the parties to comply because it is a legal process. Like he mentioned, when arbitration processes are being carried out, there is the power of the High Court that is residing. And so parties are obliged to comply.
If you don't comply, it's criminal.
Exactly, we can say so, that you have gone contrary to the law, and there can be sanctions.
Okay.
Yes,
And
we can even go to
be
court
enforced
for
at the
enforcement.
court.
Exactly.
Okay, the court is okay.
Exactly, we can go to court for the enforcement.
All right. So let me come to you on some industrial matters. It's industrial disputes on essential services. But first off, let us understand what categorizes essential service.
Oh, okay. When we talk of essential services, they are category of service providers whose services are very key,
Okay.
and that in absence of the service will cause the nation. And so such category of workers are prohibited from embarking on strike actions.
Okay.
I can give example to be Bank of Ghana, people who find themselves in water company, water providing services, electricity
ECG,
providing services, ECG,
doctors,
health service providers, people who find themselves in the transport, air service providers, and all those people fall within that category, aviation and all that, fall within that category of essential service. They are actually listed under the legislative instrument 1833. I think regulation 20 who lists those category of workers. I think they are about.
So are they forbidden on embarking on strike by the regulation?
Yes, they are forbidden.
Yes. So in the case dispute arises by way of one, maybe economic conditions, conditions of service, among other things, that
social factors.
By way of the regulations, what is the duration or timeline for them to resolve those matters?
I think that's been 3 days, right?
Yeah.
Yes. So when a dispute arises, they are to try settlement on it. If by 3 days' time they are not able to resolve, they resort to the commission, and the commission compose a compulsory arbitration process. It triggers the compulsory arbitration process. That is the second stage by which the compulsory arbitration process comes in.
Okay.
So the commission appoint 3 members of the commission, one from the government, one from organized labor, and one from employers association, to form a tripartite panel that listen to the issue. They will list the issues that they find in their complaint, refer to them, and once they accept that those are the outstanding issues, the panel, the compulsory arbitration panel meet with them and resolve it, give an award on it, an award acceptable by the majority of the members, and then that award is gazetted, and once it's gazetted, it becomes binding on them.
But I think that the Labour Commission has gone through a lot of long hustle and good work over the progress. I'm not too grown, but I remember sometime backdated, somewhere in the late somewhere before the millennial period. Sometimes you could hear of doctors going on strike. It's something that is not prevalent in modern days. I've not really heard it in a very long while now. Is it as a result of the LI imposition, or it is not that the people now have understood that they are essential service workers?
Before then, the Commission and the Labor Act was not in existence.
So
This act came into existence in 2005.
2005.
Yes.
So prior to 2005, people didn't know what essential service was.
Yes, there were other scattered labor regulations, but not collective like the Labor Act. And so labor regulations were a bit not organized as it is today.
Okay. So as it stands, we've been able to understand that healthcare services, water and electricity services, sanitary services, air transport and air traffic control services are essential services that are enlisted there.
Yeah.
Interesting. Yeah. And then transport drivers do
Transport,
Yes.
public transport.
Okay, so like
STC, Metro Mass Transport.
Okay, not Awoyomo. Not Madina Dental Trotro. Okay, thank you for the understanding. Totime,
Yes.
earlier you were trying to tell us that sometimes the duration of the whether the lockouts or the strike action, will be determined if it is legal or illegal. Now we need to then distinguish what illegal strike actions are and then what constitutes an illegal strike action.
Okay, so I would say that with the issues of legal strike, when parties serve notice on the commission and their employer, and within 7 days of the employer or the commission receiving the letter and nothing is done about it, then any time after the seventh day, the workers can embark on the strike.
Okay.
And clearly it is a legal strike. The illegal strike is when parties refuse, or the complainant or whoever it is refuses to serve the commission a notice and takes the law into his own hands and embark on the strike action. So for instance, in the case of the recent one that I gave an example of, the TEU, they wrote to the commission and the 7 days didn't expire and they embarked on the strike. Even within that period, the commission had written to them that they should stay action and appear before the commission on a set date. The set date didn't even get there, and we only heard that they have resorted to strike. So clearly it made it illegal.
So it's such an illegal case, meaning that before the commission even sits to even hear the matters, first off, the union would have to go back and call off the strike.
Exactly.
The illegality.
Exactly.
They have to undo the illegality.
Exactly.
Before they can now start properly.
So
the 7 days is going to start
the issue
even
before
the day
the
after I'm going
commission.
to call.
Yes.
Okay. That's wonderful. Beyond that, do you have any penalties that the people suffer, those who call illegal strikes? Do they pay any penalties? Do they sign any sureties? A bond of good behavior will not call illegal strike again. Do they have any measures of that sort within the confines of the regulation?
Oh yeah. Their salaries can be withheld during the period. Remember, sometimes it has ever happened in the country. It has ever happened. Yeah, somewhere in the early 2000s, President Kufuor era.
Yeah,
some teacher unions embarked on the strike.
That was illegal.
Yes, it was an illegal strike. They were ordered to go back. They refused. So their salary for 1 month or so was
no wonder I like Kufuor.
That's Graduate Teachers Association.
Yes,
Okay.
it is NAGRAT.
NAGRAT.
Yes.
Oh, that's interesting. That's interesting.
Yeah.
Anyway, our time is, we have just 5 minutes left. Let's see what we can do with the 5 minutes that is left. I would want to come to on the part of the workers. You've been mentioned of illegal strike, the penalties, people's salaries have been withheld. By the case where the mother union is the one
where there are damages, injuries, and all that, the parties are held liable to it.
Okay, okay, that's interesting. Now, when it comes to employment relationship between the employer and the employees during the period of strike, how do you manage that? Because sometimes I feel that anytime there's a strike action or a lockout, there's going to be an undue tension. There's a feud be somewhere where employers are on one side, employees on one side. Don't look at my face. That kind of thing. So how do you what is it like, and how do you manage that relationship within that period?
Well, it's very interesting.
This is that,
Yes, it's very interesting. Obviously, when you are you have a dispute with somebody, it is very difficult to look face to face.
True.
But in the midst of the law, it is stated that once steps are taken by the commission, either in the process of mediation, arbitration, or whatever, negotiation ordered by the commission, whatever, there must be a cool-off period. And during that period, all actions must be called off. Anything strike must be called off. Parties must be called back to work, and normal situations must resume. Whilst engagement is ongoing until the matter is resolved. And anybody who goes contrary to that will find himself or herself dealt with by the law.
When strike actions are lawful, do you have a duration for lawful strike actions? That this strike action should take 1 month, it should take 2 months because it is lawful. Do we have that?
Yes. When an action is declared a lawful action, you are not expected to go beyond 7 days.
Okay.
Certainly before the 7 days, the commission will set into it.
Okay.
And it will not go beyond that.
Okay. But sometimes some of the unions deliberately refuse to more of like come to an understanding with the commission, just to ensure that they go ahead and go on the strike action. Is it because you see that teacher training, teacher research allowance has not been paid, research something, school feeding has not been paid, vehicle maintenance, their
book research allowance.
Yeah,
so fee has not been paid.
so when the commission comes in to give an order, and you have refused to comply by the commission's order, then the commission can take action.
Okay.
Yes, we can't take a court action to restrain you or any other decision in the bosom of the commission, because at the time the commission has the power to make any decision on the issue.
Can an employer terminate the contract of an employee for embarking on a strike, a lawful or unlawful strike, in both ways?
Yes, if it is unlawful, any worker who embark on unlawful strike, his appointment can be terminated, remuneration can be lost, damages should be payable. But if it is a lawful strike, then the employer has no right to do that.
Okay, that's fine. Totime,
Yes.
one people that in this country, I love their way of doing, because expressing their grievances is nurses, the student nurses. They can picket. Oh, we no go agree. These are people that are not fully workers. They are students that they have been asked to promise some allowances among other things. But even in the normal scheme of things, when it comes to picketing, what does the law requires?
You see, picketing must be done by workers. It must be done by workers, and there are perimeters within which it is done. Picketing usually is sitting down closer to your workplace, not attending to your daily duties and responsibilities at the workplace, and it should be about 10 meters closer to where your workplace is. And it is legal to picket. That is also a way of expressing your grievance over certain conditions that are not so good at the workplace, and you want it to be relooked at by the employer. So legally it is right. Any worker or group of workers who intend to embark on a picketing exercise can do that.
Yeah, I've heard of unlawful picketing. What makes picketing unlawful?
Well, it could be determined as unlawful.
Notice.
Probably they haven't, first of all, served a notice to their employer. Because before one can embark or would want to embark on a picket, it means that there is a problem. And the picketing will not necessarily bring a resolution to the problem. It will take a dialogue or a negotiation. And so it is expected that the workers would always notify their employer at least 7 days before they embark on the picketing. If that is done and the employer refuses to take any action, then they can embark on the picket.
So to add to that, picketing normally goes with a lawful strike.
Oh, that's interesting. That's interesting. Doesn't mean that the students who have been going to the Ministry of Health and the Ministry of Education, what they go and do there is unlawful.
I wouldn't say it is lawful, it is unlawful.
Oh,
but in the face of the law, they haven't been, most of them who embark on the picketing are not employed. They are not fully employed.
They are not even students.
Yes,
are even out of school.
They have completed school and mostly they are pressurizing on government to bring them on board or to employ them. Yes, so they go there to sit there to tell the employer that they are ready to work, and so they should be employed.
Okay.
But on the face of the law, it is workers who are supposed to picket.
What if I become labor minister? If people are picketing, I write their names. They didn't get jobs. They will pay for the contact hours to picket before getting the job. Anyway, finally, I always say that the labor regulation always protects the employer. And then sometimes some unions are of the view that the NLC is doing the bidding of the employers. How do you diffuse this? And then how do you diffuse it? That is to you. And talk to me finally to you too. How does the law protect both employers and employees in the face of some of these industrial actions, be it strike or lockout?
All right, so let me basically say that the labor law is made for both employers and workers. I normally use workers instead of employees because in terms of technical definition, the worker covers a larger scope of than the employees. And so the Labor Act protects both, it's made for both workers and employers. And so to say that the Labor Act or the Labor Commission is in side with one against the other is unfair statement. What I may say practically is that it seems before the existence of the coming of the Act, things were not properly regulated. Work relationship seems to be more of a family issue than a formal work relationship. And so things were not done organizedly or by provisions of law. And that has eaten into today's era, which is purely regulated by law. And when workers or employers find themselves in such situation where they feel, oh, I've been very generous to you, I've taken you as a brother and sister, and you tend to do this, that is why when we speak by ways of principle, they think that we are talking in favor of the worker than the employer. But the law is very clear. When you look at the labor law section 8, you read through, it tells you the powers of the employer. It tells you that you have what it takes to formulate your own policies to regulate your work relationship. And so if you fail to formulate policies, or you formulate a policy and you refuse to comply by the policy, in terms of termination, that seems to be unfair. The worker always have the right to resort to the law, and the law will be applied accordingly. So employers who follow the law, make their policies, and go by their policies, find themselves exonerated if workers take actions against them that are not within the mandate of the law. So it's a very fair act, and act that we should always.
I think the response covers what I asked you. How the
More
law
or less.
protects. Okay,
More or
if you want
less.
to add up. Yeah.
Yeah, so I just intend to say that the Labor Act is very useful for the employer and the employee, and it makes provisions in the way labor disputes must be handled. When you read the section 135, 136, 137, talks about the establishment, functions, and powers of the commission. Whenever there are problems, labor disputes, the commission is there to resolve. unlike previously or before the coming of the Labor Act, there were these fragmented laws and decrees and so on and so forth that even seemed to criminalize some of the issues that came up on labor issues. Somebody could absent himself from work for about 3 days and he will be taken to the public tribunal and he will be thrown into jail. But with the coming of the Labor Act, it is a bit flexible and it handles matters in a way that the working relationship between the employer and the employee will not be broken.
That's more cordial.
Yes, very cordial. It can always use the law to try to resolve it on the side of the employer and the employee. The commission is there. They can always run to us. At least for now, we are operating in Ashanti region in Ahojo, opposite the Oasis of Love Church. In Western region, we can be found at Anaji. In Greater Accra, we are at Community 10, Mayflower House. And so wherever is closer. We have even started a new office in the Bono region, in Sunyani. That's the ministerial enclave. And so wherever there are problems, people can come in and they can seek our assistance.
So gradually, you are decentralizing the works of
that is what we want to do.
Wonderful.
We want to get to every part of the country so that we can help in resolving labor matters.
Let me commend you and your outfit, especially for this media engagement you are doing. It really helps people to understand this, and then I wish you all the best in the endeavors as well.
Thank you.
In the future, you are going to become one of the big commissioners in this country. Remember me when you get there. Mr. Samuel Agbenyega. Yes, he's the Principal Industrial Relations Officer. So we are very grateful for your time. And I love the way you have all the articles in your head. You are proving that indeed you are a Principal Industrial Relations Officer. When I have industrial issues, you'll be the best person I'll be following.
You are always welcome.
Don't forget the title. And then I'll come and visit you in Tema.
Thank you so
much. And see how the progress is doing there for you. So all the best. And then the Deputy PR person too, Madam Julia. Thanks for coming to us. I love your yellow. Yeah. Yes, Julia is wearing yellow. Oh, yeah. So thanks for also passing through as well. And thanks for being part of tonight's edition of PM Ghana. A very big thank you to the production crew, Salasi. I see the camera crew, I see Joshua, I see Lester and the rest. Big ups to all of you, Sasu Sound. Big ups to all of you for holding that. It's an evening. It's Thursday. Today is not Friday. So do everything that you're not supposed to do. Sleep early. And then tomorrow, Friday, we get into the world.
Osa very mo mo mo